It is important that the United States Supreme Court respect notions of originalism, which is that you interpret the Constitution and the Bill of Rights in particular, including our Second Amendment, at the time of the founding, and that the text of the Constitution and the text of the Bill of Rights is fully respected. There is a case now being litigated in front of the United States Supreme Court brought by the same lawyers and organization that represented none other than Michael Cargill in the Cargill case dealing with the bump stock, a big victory for the Second Amendment over the ATF there. But this case involves the Sixth Amendment right to a jury trial. But it's just as important to win as many other cases involving the Supreme Court and the Constitution. Let's break down why the Sixth Amendment case is so important to the Second Amendment when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say one of the few people on YouTube that has a Winston Churchill action figure behind me. There you go. Okay folks, so here's the story. The organization, the New Civil Liberties Alliance, the same organization that worked with Michael Cargill to knock out in the United States Supreme Court the ATF's bump stock ban just a year or two ago. Big win for the Second Amendment. Big win over the ATF. Well, the New Civil Liberties Alliance is back, and they're arguing another critical case seeking cert from the United States Supreme Court involving the Sixth Amendment to the Constitution. That's right. Usually we talk specifically about the Second Amendment, the right of the people to keep and bear arms. But today we're going to talk about the Sixth Amendment, which says various things, including that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, listen carefully, by an impartial jury of the state and district wherein the crime shall have been committed. Again, the key language, and the language here is particularly important in the Sixth Amendment to the U.S. Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Well, that seems pretty clear, right? It seems to me if the federal government is accusing you of committing a crime and they're prosecuting you, well, it seems like the language of the Sixth Amendment that says in all criminal prosecutions, you have a right to a jury trial in front of an impartial jury. Well, it sounds kind of obvious, right, what that says. Well, apparently it's not the case because in the case of David Lesh versus the United States, Mr. Lesh has been convicted of a couple crimes with relatively modest minor penalties, meaning less than 6 months in prison. In both cases, Mr. Lesh was convicted, and we're going to talk about those specific crimes in just a second. He was convicted, but here's the kicker, folks. Mr. Lesh was convicted in a trial before a judge, a federal judge. Hear what I just said? A federal judge, I think it was a magistrate judge, but whatever it was a federal judge, tried the case and found Mr. Lesh to have violated 2 federal misdemeanor laws dealing with alleged conduct and activities on federal land. These were crimes. He was convicted of a crime. And he was sentenced to prison. He was not sentenced to prison, but he was sentenced to, I believe, 6 months probation. He could have gone to prison, but he didn't because the judge did not sentence that. But here's the kicker. He requested to have a trial by a jury of his peers, by a jury and not a judge. But the judge said the U.S. Supreme Court historically has said there's an exception to the Sixth Amendment's right to a jury trial. And that exception is for what are known as petty offenses. Petty offenses. Well, what is a petty offense? A petty offense as defined by the United States Supreme Court is an offense for which you could not go to prison for more than 6 months. Or you could be sentenced for something other than prison. Something along those lines. Some sort of minor offense. But in theory, you could still go to prison for many months. He asked for a jury trial pursuant to his Sixth Amendment rights. The court said no. The reason why we're saying no, you're not entitled to jury trials, because the U.S. Supreme Court and prior precedent has said there's an exception to the plain text of the Sixth Amendment for petty offenses, i.e. minor federal offenses. Well, Mr. Lesh has taken this case all the way to the United States Supreme Court and said, look, and this is where the Second Amendment plays a role. His argument to the U.S. Supreme Court is this: look, this court is trying to engage in originalism. Now, what is that? It's really actually basic law. It's basically saying that you read the Constitution as it's written and try to understand what the writers, the drafters of the Constitution meant, in this case, the Sixth Amendment. And then you might look at some history associated with it. But you're laser focused not on what's convenient for federal judges and federal politicians today and federal regulators today. You try to understand what the law is. And the argument here is there's simply no way to get around the unambiguous language of the Sixth Amendment that literally reads, in all criminal prosecutions, the accused shall enjoy a right to a trial by an impartial jury. That's the text of the Sixth Amendment. Sounds pretty unambiguous. So how is it that the Supreme Court has historically carved out these exceptions? And this case of Lesh versus the United States advanced, on appeal by the New Civil Liberties Alliance, the same group that worked with Michael Cargill in the bump stock case, is trying to get the Supreme Court to take this case and to fix that past precedent set undeniably by liberal judicial activists on the Supreme Court decades ago, and try to rectify this once and for all. Now, why is this important to the Second Amendment? And then we'll get to some of the interesting facts of Mr. Lesh's case just by way of background. This is particularly important to the Second Amendment for the following reasons. It is extremely important, in my opinion, that we really make sure that the notion of originalism suffuses itself or kind of embodies or is entirely runs throughout the entire Bill of Rights. Because the more that originalism, which is understand the text of the Second Amendment, understand the text of the Sixth Amendment, understand the text of the Constitution, as it was understood by the drafters of the document, using the history from the relevant time periods, as opposed to modern-day conveniences and efficiencies and multi-part tests just invented by courts today. We want originalism and the focus on the text and the meaning of the text and the history of the text of all constitutional rights, including everything in the Bill of Rights, for example. The more this becomes the rules of the road, the more this becomes the standard for interpreting the Constitution in all respects, including, but not limited to, the Second Amendment's right to keep and bear arms, and in this case, the Sixth Amendment's right to a trial by a jury, the better it is for all of us. The better it is for the Second Amendment, the better it is for the Bill of Rights, the better it is for American freedom. And remember, there's something that I've talked a lot on this channel, but this is a point that I make in actually kind of more erudite settings with judges and law clerks and scholars and other kind of geeks of the Constitution, and that's this. If you want the theory of originalism to succeed in American jurisprudence, it is mission critical regardless of what is your main issue. If your main issue as a conservative is abortion rights, if your main issue as a conservative is religious freedom, if your main issue is the First Amendment, if your main issue is the right to keep and bear arms, it doesn't matter. Let me be very clear, and this is the point I make, like I said, in a lot of sophisticated circles of people that are, very erudite when it comes to constitutional theory and all that, but I'm going to break it down for you in a very basic way, and that's this. If the Supreme Court today and federal courts and scholars are not able to make the theory of originalism work in the context of the Second Amendment's right to keep and bear arms, originalism cannot work as a theory in any aspect of the Constitution, in any aspect of constitutional law. And why do I say this? Because unlike all other aspects of the United States Constitution, the Second Amendment has relatively few precedents on the books. So if you cannot make originalism work in the Second Amendment context, where you're really dealing with what I like to call blue ocean, right? You don't have a bunch of crazy anti-American precedents on the books by judicial activists. There were nutty liberals, okay, like we saw in the 60s and 70s. You got none of those barnacles on the Second Amendment. So if you can't make originalism work in the Second Amendment, where you don't have obstacles and barriers and problems associated with precedents that are nonsense that you have to overcome, it can't work for anywhere else. So with that said, we in the Second Amendment community should be cheering for originalism. We should be cheering in this context of Lesh versus the United States that the Supreme Court does take this case and instruct the lower courts in America that when the text of the Sixth Amendment says in all criminal prosecutions you get a right to a jury trial, that means exactly what it says, in all criminal prosecutions. And this connection and the importance of this has not been lost on many other peoples. And here's a great quote from Kara Rollins, the litigation counsel for the new Civil Liberties Alliance, who makes a very powerful point that I agree with. Juries have long played a critical role in our nation as they provide a check on legislative, prosecutorial, and judicial powers. But the petty offense exception eliminates that protection for many defendants. That's right. Kara Rollins says, in modern America, where the number of federal regulatory crimes ranges between 300,000 and the unknowable, again, completely correct. You cannot know the number. It's insane, though. It's a huge number. Restoring the full civil trial right in all criminal prosecutions is long overdue. I 100% agree with what Kara Rollins said there. We have no idea how many nutty regulations are on the books. There's somewhere north of 300,000 to who knows what. No one knows. Even people like Senator Mike Lee from Utah have tried to figure out the number of federal crimes. No one knows. I think Supreme Court Justice Neil Gorsuch has made this observation, and we still don't know the number of federal crimes. Nevertheless, what we do know is that because of liberal judicial activism in the past, there's an exception to the clear text of the Sixth Amendment when it comes with petty offenses and whether or not you're entitled to a jury trial. And that should not be the law. And just by way of background, just because I think you might find it interesting, here are the facts of the David Lesh case, who of course maintains his innocence in all respects. But kind of interesting facts. And this is what will be before the Supreme Court if the Supreme Court grants cert. An accomplished skier and founder of the outdoor gear company Vertica, I hope I pronounced that correctly, Mr. Lesh posted 2 photographs on his personal Instagram account in April 2020 that depicted an unidentifiable snowmobiler performing a jump at Colorado's Keystone Ski Resort. The resort rests on the United States Forest Service administered land and was closed at the time due to COVID-19. How nutty is that? I digress. Mr. Lesh's Instagram post did not mention Vertica, nor did it promote the company's products. Nevertheless, a federal magistrate judge convicted him of violating one regulation prohibiting operation of a snowmobile outside of a designated route and another conviction banning unauthorized work activity or service on United States forest lands. Mr. Lesh's request for a jury trial was denied because of the U.S. Supreme Court precedent declaring he was not entitled to one for a petty offense. Very interesting background facts. We'll see what the Supreme Court does. I will certainly keep you apprised as to what the Supreme Court does, if anything, in this Lesh versus United States case. But again, it's very important for our Second Amendment rights because, as I've explained before, the way to envision American law, especially those that protect all of our rights and freedoms, is think of a spider web in your mind, a spider web. And anytime you pull a single strand of that spider web, you have to understand that the entire spider web is going to move. And by metaphorically, the reason why this is important as a metaphor to American law is every time you have a court decision that touches on our freedoms, on our rights in any respect, it is somehow, some way moving, sometimes in a big way, sometimes in a small way, that spider web of American constitutional law and American law. So even if we get a favorable ruling involving the Sixth Amendment's right to a jury trial, you may be like, hey, what does that mean, Mark? Well, the answer is it's good for freedom because it's better to have a jury of our peers in most instances decide whether or not we're guilty. And of course, you always have the right to waive that jury trial, by the way, but you should always have that right. That's very important for freedom. There's a reason why the Founding Fathers created the Sixth Amendment. There's a reason why they created the First Amendment. There's a reason why they codified the right to keep arms in the Second Amendment. Our Founding Fathers were very wise and very concerned about governmental overreach and tyranny infringing upon our individual freedoms as Americans. So we should take the words of our Founding Fathers very, very seriously, whether it be in the Second Amendment or in the case of Lesh versus the United States, in the Sixth Amendment. So there you have it, folks. Hope you learned a little bit something here today about the Sixth Amendment and how it ties into originalism and the Second Amendment, and why we should all be cheering for these in front of the U.S. Supreme Court. Make sure you follow me on X at Four Boxes Diner. We have over 22,000 followers there. And make sure you subscribe to the channel both on Rumble and YouTube. We're trying to get to 200,000 subscribers on YouTube, and I look forward to talking to all of you very soon here at the Four Boxes Diner.
Orders up. Table 2A.